Greetings, my name is Ezzati and I am the legal officer here at the Malaysian Institute of Integrity. For today, I'll be speaking about corporate liability in line with the introduction of the new Section 17A of our MACC Amendment Act 2018. Alright, here we go. So first and foremost, let's try to figure out what is corporate liability. So corporate liability is actually the legal responsibility of a corporation for criminal actions or the failure to act in some cases committed by the company's employees if the actions were done for the benefit of the company or a result of negligence, or if they occurred due to a lack of responsible management by the company, the corporation can be prosecuted and punished. But for the meaning under Section 17A, commercial organizations are now liable for any act of bribery or any corruption-related acts by an associated person to the commercial organization. Commercial organizations would then be liable for those acts. It's pretty similar to the idea of vicarious liability if you are familiar with it, except that now there's no relationship between an employer and employee. Instead, it's between a corporate liability and any associated persons. Alright, in understanding Section 17A, let's get into some key questions we'll try to answer. For part 1, I'll only be answering 2 questions, which are who are liable under this provision and what are the misconducts under this provision. Let's get right to it. Alright, who is liable under Section 17A? We'll be reading through Section 17A, but then we'll be focusing on different parts in order for us to be familiar with the provision. For this time, we'll be focusing on the term commercial organization. A commercial organization commits an offense if a person associated with a commercial organization corruptly gives, agrees to give, promises, or offers to any person any gratification with the intention to retain or obtain an added advantage or retain and obtain any business opportunities. Alright. Actually, our Section 17A is quite comprehensively drafted because if you look into Section 17A, Subsection 8, it actually already explains the list of criteria of commercial organizations. Right here it says that local companies that are established under the Companies Act 2016 and foreign companies that carry on businesses in Malaysia, local partnerships established under the Partnership Act and Limited Liability Partnership Act accordingly, and foreign partnerships that carries on businesses in Malaysia. So basically, the quick way to answer whether your commercial organization is under Section 17A is to answer whether you were established under these 3 acts, Companies Act 2016, Limited Liability Partnership Act, and the Partnership Act. If you're not, then do not worry, this section is not for you. Here we go. There are also some questions people are circling around this Section 17A. Like, are statutory bodies considered as commercial organizations? Are societies considered as commercial organizations? Although they do carry on businesses as well, the simple answer is no. That is because statutory bodies are usually established under their own acts, whereas societies are established under the Registrar of Societies. So quickest way to answer this is no. They are not a commercial organization under Section 17A. But keep in mind that although they are not liable under Section 17A, if they were to do any acts of bribery, they will still be charged under Section 16 or Section 17 of the MACC Act 2009. Now that we've answered who is liable under Section 17A, let's look into some misconducts you would definitely want to avoid and prevent from doing. What are the wrongs done under Section 17A? Again, to familiarize ourselves with the provision, we'll be reading through the provision again, except this time we'll be focusing on a different part. Here we go. A commercial organization commits an offense if a person associated with a commercial organization corruptly gives, agrees to give, promises, or offers to any person any gratification. I do understand that in our society, we tend to think that gratification actually just means money or property, but that is actually far from the truth. If you look into the MACC Act 2009, the definition of gratification extends beyond money and property. It also includes valuable considerations such as discounts and rebates, release of monetary legal liability or release of liability against any loan, for example, your PTPTN loan, your car loan, offers and employment, basically promising someone that they will get a job if you give them an added advantage in the course of business, service or favor such as protection against any penalty or forbearance of the same. Please understand that although all that I've mentioned before are things or items under gratifications, one thing that you need to be cautious about is the fact that slightly offering or merely promising towards the action mentioned above are also considered as gratifications as well. Alright, Another thing that they've added with Section 17A is the intention of such misconduct. So in order for one to be charged under Section 17A, it has to be proven that your offer or your promise of gratification must include the intention to obtain or retain business for the commercial organization, to obtain or retain an advantage in the conduct of business for the commercial organization. So basically, you would have to prove that giving gratification or offering these gratifications are for the purpose or for the benefit of that commercial organization itself. Understand that this provision is only applicable if it can be proven that this intention exists in offering or receiving such gratifications by these associated persons. Alright, as of now, we'll be only looking into these two questions, whereas in part 2, I'll be explaining further on who are these associated persons, probably the most frequently asked questions, and also what are the penalties imposed if you are found to be liable under Section 17A. Until then, thank you for your attention. I'll see you in part 2. Hello, picking up from where we left off before in part 1, right now we'll be answering questions on who are the associated persons mentioned in the provision. Probably the most frequently asked questions, because these are basically the culprits, the people you'll have to look out for in order to not be charged under Section 17A. Provision of Section 17A actually also has explained who are these persons associated. Let's take a look at Section 17A, Subsection 6. Directly, they have included directors, partners, and employees. And then they have added on another one that might be open to multiple interpretations. They call them he or she who performs services for or on behalf of the commercial organizations. Let's call them service providers for short. All right, who are these service providers? Service providers would include agents, partners, and any potential partners of joint ventures that are determined by relevant circumstances instead of the nature of relationship. Understand that we still do not have any precedents in regards to Section 17A, so we can only assume that service providers would extend to the people that I've mentioned before this. If you look into the adequate procedures that has been issued out by the Minister, they have actually also added a few more people under the definition of associates. So probably you might be able to look into that to determine who are the service providers as well. And when I said that they are not determined by the nature of the relationship, this would mean that there is no requirement for a formal agency agreement or a formal service agreement. So long as the circumstances can portray such a relationship, these people are to be considered as associated persons to your commercial organizations. So be mighty cautious, because you never know who are these people performing services for or on behalf of you and are acting in such a way that would bring you towards Section 70A, corporate liability. Alright, now that we've tried to understand who are service providers, let's look into the not so fun part of it all, which are the penalties imposed if you are charged under Section 17A. Alright, Section 17A, Subsection 2 has stated that on conviction, a commercial organization will be liable to a fine of not less than 10 times the sum of the gratification if it is able to be calculated, or ₦1,000,000 ringgit, whichever is higher, or an imprisonment up to a maximum term of 20 years, or worse, both. Alright, if you are familiar with the act of bribery under the MACC Act, you would see that this is a whole lot heavier imposition of penalty. Because if you are caught with the act of bribery, your penalty would only be 5 times the value of gratification. As if that's not high enough, corporate liability now comes with 10 times the gratification value. So just be wary of this little part of the penalty imposition. Alright, now let's look into the more confusing part. Imprisonment up to 20 years. How can you imprison a commercial organization, you may ask? Actually, corporate liability has introduced a concept called parallel personal criminal liability, whereby the criminal liability not only falls on the commercial organization, but what happens is that senior personnel such as the director, controller, officer, partner, or persons who is concerned with the management of the commercial organization will also be personally liable as if they have committed the act of bribery themselves. Naturally, in law, you are innocent until proven guilty. But one thing about corporate liability, these senior personnel are presumed to be guilty until they can prove their innocence. Alright, how would these senior personnel prove their innocence then, you may also ask? let's look at the defenses available for the senior personnel to ensure that they're not jailed to a maximum term of 20 years. What they can show is that first, the offence of bribery is committed without their consent and without their knowledge. Other than that, they would also have to prove that they have exercised due diligence to prevent such commission as he ought to based on his position. So for example, if you are a director, you would have to prove that you have exercised due diligence. For example, you have drafted an anti-corruption policy, dissipated it among your employees. Now that means you have exercised due diligence to prevent a commission of bribery. However, keep in mind that despite successful defense of the senior personnel, it does not mean the charge is dropped. Commercial organization would still be liable towards a monetary penalty until they have proven their defenses. Alright, we'll look into the available defenses of commercial organizations in Part 3. And also a little add-on, I've added on why or what should members of a company know as regards to Section 17A as well. Alright, until then, we'll look forward to Part 3 of the series. Thank you. Alright, now let's go into the defenses available for these commercial organizations to ensure that they are not charged with the penalties that I have mentioned before. Alright, let's look at what are the defenses under Section 17A. If you look at Section 17A, Subsection 4 and 5, it is provided that it is a defense for the commercial organization to prove that the commercial organization had in place adequate procedures to prevent such mishap. And later on, in 17A, Subsection 5, it states that the minister shall issue guidelines relating to the procedures mentioned in Subsection 4. Right, if you look to the right, you'll see actually a picture of the guideline on adequate procedures that has already been provided by the Prime Minister Department. You can just Google it and you can find the entire adequate procedures to your convenience. All right, what is actually in this guidelines? So this guidelines is not prescriptive. Understand that it is just merely a guideline. But when the court is trying to evaluate whether your commercial organization had in place an adequate procedure, these guidelines will be taken in heavily and will be considered as a sample of whether your company has actually put in place adequate procedures. Right, let's look into what is actually in the guidelines provided by the Prime Minister's Department. They've actually created this fun acronym of TRUST or trust, hence why I've created a slide entitled Earning the Trust for a Defense. So what is trust? T stands for top level commitment. Basically what they have to do, the senior personnel would have to ensure that there is the highest level of ethics and integrity throughout the entire company. Secondly, R would stand for risk assessment. The guideline has actually recommended that a risk assessment, a comprehensive risk assessment, is to be undertaken once in every 3 years. Then there's U for undertaking control measures. What you have to do is establish policies and procedures like the NACP plan that has been taken out by the Malaysian government a few years back. Then there's also S for systematic review, monitoring and enforcement. Things like you could have requested third-party auditors to come into your company and create an insurance of compliance by getting probably ISO 37001. And then there's also T, training and communication, ensuring that there is adequate training to the employees of your commercial organization and communication of policies to your third parties. For example, if you get into a contract with a subcon, you have to make sure that you communicate your anti-corruption policies to them to ensure that they, as an associated persons, will not be acting on the misconducts that I have explained before this. All right, some example of defenses. Let's look into adequate procedures examples. This is actually some of the products that are provided by us at the Malaysian Institute of Integrity. Those products would be Organizational Anti-Corruption Plan, or usually we call them OACP, Corruption Risk Management, and also Anti-Bribery Management System. These three products or services are things that you can implement into your commercial organization in order to ensure that you have in place an adequate procedure as a solid defense in the event that you are charged under Section 17A. Products provided by IIM are suitable to prove that the company has taken the reasonable steps towards the defense. All right, we're actually done with the whole part of Section 70A on corporate liability. So now you'll have to understand that even though you have a successful defense of Section 17A, the associated person must still prove that they have not done such act of gratifications. If they are proven to be offering or receiving gratifications, they would then be charged under Section 16 or Section 17 of the original MACC Act 2009 under their personal capacity. Now, an add-on to the whole idea of corporate liability is the duties of members of company. Your members of company, what should they know as regards to Section 17A? There is actually a duty to report under Section 25 of the original MACC Act 2009. It states that any person to whom any gratification is given, promised or offered in contravention of any provision of the original MACC Act shall report such gift, promise or offered together with the name, if known, of the person who gave, promised or offered such gratification to the nearest officer of the commission or police officer. Let's just put it in simple words. What is the duty to report bribery transaction? Is you'll have to keep two things with you. Number one, you have to keep the information of the offer that has been promised or requested. Number two, you'll have to keep the name of the person offering or receiving such gratification, bundle those two together, send it over to the nearest police officer or the nearest MACC officer to where you are. And that you have fulfilled your duty to report such bribery transaction. Why am I talking about this? Because this is not just a recommendation, this is actually a duty. So if you do not report such bribery transactions, it is an offence of not reporting. Section 25, Subsection 2 of the MACC Act 2009 has imposed a penalty on those that do not fulfill the duty to report bribery transactions. These penalties would include you would be liable to a fine at a maximum of 100,000 ringgit, imprisonment at a term of 10 years maximum, or worse, both. So make sure that it is a collective effort between the entire commercial organisation to ensure that Malaysia is now in possession of a clean economic slate, whereas we are corruption-free and we do not tolerate bribery. So let's just get a recap of Section 17A. So if you are charged under Section 17A, they will determine the associated persons. Who are these associated persons? It is determined by relationship by the circumstances instead of the nature of relationship. Then your senior personnel would have to present their defences. What are the defences available? That it was done without any consent and they have exercised due diligence to ensure that their associated persons would not do such a thing. And company would also have to present their defences by implementing adequate procedures. That would be all for the explanation of corporate liability. Again, I thank you for your attention. I hope with a simple presentation, it would make you understand corporate liability even better. Thank you.